Good evening. My name is Paul Hauk, and I serve as president of the Phi Beta Kappa Association of Kentuckiana. On behalf of our association, I welcome you to our very timely panel discussion entitled, Can the Constitution Survive the Pandemics of 2020? I especially want to welcome and thank our distinguished panelists this evening, Dr. Jasmine Ferrier, Professor Sam Markison, and Professor Cedric Powell, as well as our moderator, Judge Fred Cowan. Before we get into tonight's program, I just wanted to say a few words about the Phi Beta Kappa Association of Kentuckiana. Our association is one of approximately 50 Phi Beta Kappa associations in the United States and the only association in Kentucky. While our membership is primarily made up of Phi Beta Kappa alumni residing in the Louisville and Southern Indiana area, our members represent colleges and universities from across the country. Our association's goals are to promote liberal arts and sciences education and to recognize student achievement and locally through the provision of book awards and scholarships. Consistent with our goals, we hold various programs throughout the academic year. In a normal year, of which 2020 is clearly not, most of our programs would be held in person. But through the magic of Zoom, here we are, and we are delighted that so many of you could join us tonight through this medium. I would also like to take this opportunity to invite everyone to join our next free Zoom program on October 15th. That program will be an author forum featuring Cassie Chambers Armstrong, entitled From the Hills to City Hall. More information on that program, our Phi Beta Kappa Association, and how you can offer financial or other support to our goals can be found on our website at pbkky.org or find us on Facebook. Finally, if you have been inducted into Phi Beta Kappa and are not yet a member of our association and would like to be, that can also be accomplished by visiting our website, again, pbkky.org. As we move into tonight's program, a couple housekeeping matters. I would ask audience members to please turn off your video and mute your microphones to help with bandwidth and to eliminate background noise. Also, during the course of tonight's program, we both invite and encourage questions to be answered by our panelists. We ask that you submit questions via the chat function to Jeremy Wells, a designated co-host for this event. Also, this program will be recorded. And now it is my honor and pleasure to introduce our moderator for tonight's program. Judge Fred Cowan was a circuit judge in Kentucky's 30th Judicial District from 2007 to 2017. In that capacity, he tried more than 100 civil and criminal cases, including many dealing with constitutional rights. He was a member of the Kentucky General Assembly from 1981 through 1987 and served as Attorney General of the Commonwealth from 1988 through 1992. While Attorney General, Fred successfully argued the case of Stanford versus Kentucky before the United States Supreme Court. Judge Cowan is the rare Kentuckian who has been elected to all three branches of Kentucky state government. Now retired, Fred was in private practice of law for many years. He is a graduate of Atherton High School, Dartmouth College, and Harvard Law School. We are very pleased to have Judge Cowan with us this evening. And with that, I turn the program over to Judge Cowan.
Thank you so much, Paul. It's a pleasure to be here and to host this distinguished panel. The Constitution is the legal and moral framework for our democracy. Among other things, it determines how our leaders are chosen and how we distribute power between the central government and the states. It is the basis of our rule of law, without which we would be relegated to a society where the distribution of power, property, and wealth would be based on personal whim, favoritism, corruption, and physical dominance. Our Constitution also enshrines in its text a coronation of individual rights vis-a-vis the government in the Bill of Rights, which was adopted shortly after the original Constitution was ratified. As we know, however, those rights at that time excluded several million human beings who were enslaved. And then, 75 years later, after the lives of about 750,000 citizens from the North and the South were lost in our great Civil War, the 13th, 14th, and 15th Amendments to the Constitution were adopted, those guaranteeing the rights of citizens, including those formerly enslaved. Our Constitution is viewed as one of the greatest, perhaps the greatest, string of words governing human beings ever put to paper. But keep in mind 2 points. First, in practical terms, it has come to mean only what the justices of our Supreme Court have said it means. Secondly, that meaning is a matter of bitter dispute, and the Constitution and our respect for it have proven to be malleable. It depends on the circumstances. It depends on the justices. Shamefully, and in hindsight, there have been instances in which our nation, through its willingness to accept the results and abide by the Constitution, has accepted results that are appalling. In the Dred Scott decision of 1857, the Supreme Court held 7-2 that African Americans were not and could never be citizens of the United States, despite the fact that the Missouri Compromise of 1820 declared that all territories west and north of Missouri would be free. The Civil War was fought. The 13th, 14th, and 15th Amendments were adopted. And then in the height of the Jim Crow era, the Supreme Court found by a 7-1 majority that the Equal Protection Clause of the 14th Amendment, as it applied to states, meant that states could provide for totally separate facilities and treatment of African Americans as long as those facilities and treatment were, quote, equal, the so-called separate but equal doctrine. And in the Korematsu decision after World War II, the court held by a 6-3 vote that upheld the right of the U.S. to evict citizens, United States citizens of Japanese descent from their West Coast homes and require them to stay in detention camps. With this background, we come to today's twin epidemics, pandemics, coronavirus, and the struggle for racial justice. One is a public health threat that has been also described as a national security threat. The other is a systemic issue that threatens our sense of moral security and superiority. The Constitution impacts both. What constitutional powers does the United States government have to impose restrictions on its citizens in order to keep them safe? Can the president command governors to stop commerce or close schools? What happens when those restrictions conflict with individual rights in the Constitution, such as the freedom to worship, the freedom to assemble, the right to bear arms? With respect to racial justice, does the Constitution provide protections for Black citizens who believe they face unequal treatment by police? Does the Constitution give citizens the right to protest as they see fit, as long as they are not violent? Does the Constitution give citizens the right to bear arms as part of a group that says it feels threatened by street violence? These and other questions are the ones that will be touched upon by our panel today. As I mentioned, we have an extremely distinguished panel, and I'd like to introduce them. I will give a description of their backgrounds all in the beginning, and then we'll turn it over to them for their comments. Dr. Jasmine Ferrier is Vice President of University Development, Professor and former Chair of the Department of Political Science at the University of Louisville. Dr. Ferrier studied U.S. separation of powers theory and development at the University of Texas at Austin and received her PhD in government in 2000. She was a fellow with the Miller Center of Public Affairs at the University of Virginia from 2000 to 2001. In 2002, Dr. Ferrier joined the Department of Political Science at the University of Louisville. Her current courses and research span all three branches of the U.S. government, including a new book on inter-branch lawsuits, separation of powers, and constitutional law entitled Constitutional Dysfunction on Trial, Congressional Lawsuits and the Separation of Powers. She's a popular professor and recipient of numerous awards for service, teaching, and instructional development, including the Distinguished Service Award from the College of Arts and Science and the University President. Professor Samuel Markison graduated from Yale Law School in 1986. After clerking for Judge George C. Pratt on the Second Circuit Court of Appeals, he joined the appellate staff at the Equal Employment Opportunity Commission in Washington, D.C., where he spent the next 8 years briefing and arguing cases in the federal courts of appeals. During that time, Professor Markison also helped to design and conduct the EEOC's training program for its employees after enactment of the Americans with Disabilities Act before it went into effect in 1992. In 2002, Professor Markison published the book, Original Sin, Clarence Thomas and the Failures of the Constitutional Conservatives. It takes a critical look at the record of the Supreme Court's most conservative members. Since joining the faculty at U of L Law School, Professor Markison's research and writing has concentrated on constitutional law, especially the 14th Amendment, and the civil rights issues facing lesbians, gay men, bisexuals, and transgendered people. Professor Markison teaches constitutional law, sexual orientation in the law, employment discrimination, and criminal law. Professor Cedric Powell is the Wyatt Terrington Combs Professor of Law at the University of Louisville Law School. Professor Powell received his JD from New York University School of Law, where he served as managing editor of the NYU Review of Law and Social Change. Prior work experience included a judicial clerkship with the Honorable Julia Cooper Mack of the DC Court of Appeals, and a one-year term as Karpatkin Fellow in the National Office of the American Civil Liberties Union in New York. Professor Powell has written over a broad range of topics, including affirmative action and critical race theory, First Amendment and hate speech, and the 14th Amendment and structural inequality. All of his scholarship critiques neutrality as a means of preserving structural inequality and advances theories of substantive equality, which reject colorblindness and post-racialism as normative principles in constitutional analysis. He has received numerous awards, including the University of Louisville Multicultural Teaching Award in 2002. He was recognized by the historic Chestnut Street YMCA as a 2014 Adult Black Achiever. He was also awarded the 2014 LBA Justice William E. McAnulty Jr. Trailblazer Award, the first law professor to be so honored. We're delighted to have all three of you, and thank you for your participation. And Dr. Ferrier, we're going to start with you, and we'll turn the podium over to you for your comments. Thank you very much.
Well, thank you very much to our honorable moderator, Fred Cowan. I also want to thank Paul, Gail, Greg, and the PBK of Kentuckiana group for having us tonight for an always timely discussion. Pandemic or not, it's always a good time to discuss the Constitution. If it's all right, I'd like to take a polite step away from one of our moderators' opening comments just to frame up my political science perspective on the Constitution. So, Mr. Cowan, you said that the Supreme Court tells us what the Constitution means. And I would say that my point of view as a political scientist and as an institutionalist studying American political development, I would say that it's all of us who are in the constitutional interpretation business. So again, I think that the lawyers among us might differ, but I would start from the idea that if the Supreme Court were the last word on constitutional interpretation, we wouldn't have had 40 plus years of fights over abortion, for example. So in other words, the court settled nothing in 1973. In fact, if anything, they unsettled the idea that this was a state issue. I would argue quite the opposite, which is that the understanding of American constitutional development is best understood as a political fight. And it's a legitimate political fight because the framers envisioned, although they envisioned only white men with property and white men with property as voters, what they envisioned was that there would be organic differences in the way that every House member, every senator, every president, and every federal judge sees the same thing. Instead of just fighting over rights and over powers, my point of view looks at the structures of the American Constitution as an invitation to struggle. And ideally, as I do agree with Mr. Cowan, that we have an invitation to struggle that should be peaceful. That invitation to struggle comes up every 2, 4, and 6 years. And it's not just in the elections that we have and the outcomes and the majority arrangements, but it's also the point of view of the place of the office holder. What is a House member to do? Who are they beholden to? Everyone who sits in the House is a winner. Ideally, they won fair and square. Everyone who sits in the Senate is a winner. Again, ideally, they won fair and square. We might argue the same would go for the White House and for federal judges who are appointed for life terms as per the original constitutional text. We can forgive ourselves for being afraid of conflict, but the history and the longevity of the United States Constitution actually embraces it. If we look at the history of African Americans and other underrepresented minorities in public life, what we see then is not only a rich separation of powers fight that obviously became quite bloody, but we also see the history of the states. So federalism is as much a part of the Constitution as separation of powers. And we welcome, not always, but we welcome, according to our own political and policy sensibilities, when states differ from the national majority. So if you're a Californian and you want to buck the national majority on marijuana or on climate change, that is something that many state majorities do embrace. We have to be careful because you know the old saying about foolish consistency. We have to note that we don't just have biases and prejudices in the subconscious parts of our mind, but we have open prejudices, and we would call that the right to advocate. The political arena, if properly structured, would be a place for us to air these differences and settle them peacefully. And I think that the country has been through worse than this year, and we have to keep our perspective on that. And obviously, I look forward to the comments of my fellow panelists. Those are my opening remarks. Thank you very much for having me.
Thank you very much, Dr. Ferrier. Sorry. Thank you very much, Dr. Ferrier. And now we return to Professor Markuson for his comments.
Thank you. And I would like to echo the remarks of Dr. Ferrier, thanking our hosts for arranging this discussion. I think it's going to be fascinating, and I hope that the audience agrees and that we get a great and vigorous discussion going. I guess my view is that I'm slightly, perhaps more pessimistic than Dr. Ferrier is on the question of the strength and viability of the Constitution in these times. I don't know whether we've been through worse, at least since the Civil War. And the Civil War obviously represented a very different challenge, a very different kind of challenge to our constitutional order. And I would argue that the constitutional order that existed before the Civil War did not survive that particular crisis. It precipitated enormous change that took a long time to become manifested in reality, and we're still trying to reach the truth and actually implement those post-Civil War amendments. But the point is, great crises in our history have almost always been met by a significant change in our constitutional structure. Sometimes that has been through the amendment process, and sometimes it's, of course, been through the interpretation of the Constitution, through the way we envision the Constitution, through the dialogue that Dr. Ferrier talked about, as well as through Supreme Court decisions that shape the structure of our government, that shape the powers of our various governmental levels, the branches of government, and the Supreme Court itself. I suspect that this is one of those moments that our understanding of our constitutional order, our understanding of how we relate to one another politically, is undergoing a paradigm shift that is almost impossible to predict where it's going. If it were just a global health pandemic, I say that I should probably put that in quotes. If that were all we were facing as a challenge, we faced those before, and pandemics that frankly were much greater threats to the public health than COVID-19. But COVID-19, not to be too cute about it, is merely a symptom. It's not the disease that actually afflicts our constitutional order. It shows the strains that our constitutional order is under, as does the way we are dealing with the problems of racial injustice in our criminal justice system, in our economic system, in our educational system. And the response to those has been so sluggish and met with dysfunction and inaction that it demonstrates something pretty fundamental. And I think that fundamental nature does represent a threat to the way we have governed ourselves, at least since the end of World War II, it's been an era of mostly consensus governance, where we've been able to reach compromises on significant public health, public issues that have faced the country. And that has broken down as we've seen more partisanship, as we've seen more polarization in our politics. That crisis, at a time when we're trying to deal with such important issues as the pandemic, as racial injustice, it becomes much more difficult to reach consensus on how to solve or at least address those issues. And I'm far from convinced that we will find our way clear to a new paradigm without massive upheaval. And that may be as soon as, it probably is ongoing, but it may be as soon as November of this year, when we see how the very foundation of our democratic governance under the Constitution, the election of a president and a new Congress, whether those can be achieved in a peaceful way with perhaps an orderly and peaceful transition of power. We have various threats. We have a president, in my view, who is calling into question the basic norms that have governed us, at least in the post-World War II era, of constitutional governance, with congressional oversight, with judicial independence, with transparency in government. We have what I would view, in my own perspective, is an extreme version of libertarianism that calls into question the very premise of governance, the very idea that government can limit liberties in something like a public health crisis in order to deal with the transmission of an epidemic disease like COVID-19. And those sorts of challenges are ones that are disturbing, are troubling, and leave me quite uncertain about the future of where our constitutional structure will be, let's say, 6 months from now. So that's where I would open with. That's my unfortunately somewhat pessimistic take, and I can't wait to hear what Professor Powell has to say, and then to take some questions from our audience.
Thank you very much, Professor Marcuson. Now we turn to Professor Powell for his comments. Professor?
Good evening. Thank you, Judge Cowan. I want to thank the organizers, Drs. Gail Henson and Greg Hutchison, and thank Paul Hope, president of Phi Beta Kappa of Kentuckiana, Bellarmine University. And I appreciate this opportunity to offer some comments on this important subject, along with my colleagues on this panel. Can the Constitution survive the pandemic? My answer is yes, but I ask the question, but how? My remarks tonight will focus on three themes: the structural Constitution, the scope of the pandemics and the impact of this destructive and disruptive power, and finally, an example of the Roberts Court's post-racial constitutionalism. And I will try to conclude on a hopeful, if not unduly optimistic note. These are existential times, and we should recognize them as so. So for context, let's talk about the pandemics. Pandemics are global. We are in the midst of an economic recession, depression, a racial reckoning. I don't like this term because race has always been there. The 1619 Project conclusively illustrates this, and climate change. So we have 4 pandemics. And on top of all of this, we are in the midst of the third Reconstruction, a period of retrenchment and retrogression that continues after the first 2 Reconstructions, the period after the Civil War, and then the modern civil rights struggle, beginning with Brown versus Board of Education in 1954, to our current Reconstruction, which is a violent reaction on every level to the 2-term presidency of Barack Obama. As with other Reconstruction periods, there's a longing and nostalgia for what was before, an America where everyone knew their place, or more accurately, where subordination and subjugation was deemed appropriate for African Americans and people of color by custom, practice, and by law. I say all of this not to give you a history lesson, but to emphasize the present day effects of past discrimination. Now everyone acknowledges, for the most part, structural inequality. So we live under a structural constitution, one of enumerated powers, co-equal branches of government, separation of powers. No branch should aggrandize itself at the expense of other branches of government. And we also conform to a set of democratic norms and first principles. But those first principles must be actualized. Pandemics explode when their underlying causes are ignored for years, decades, and generations. And when they inevitably explode, we are surprised by the disruptive power that they wreak across all of our societal systems. We have recently discovered that structural inequality and systemic racism are real, and look what it took for society to come to this resolution, this realization. The real-time lynching of George Floyd and the state-sanctioned execution of Breonna Taylor. Both unarmed, both brutalized by disproportionate force on Black bodies. But what is so devastating about our current state of affairs, even to this day, is that our democracy actually normalizes what is occurring because of its fidelity to ostensibly neutral principles. In the interest of time, I want to focus on the Roberts Court and post-racial constitutionalism, an attempt not merely to neutralize race, but to move beyond race based on a contrived narrative of racial progress. There are three cases, but I won't go into all three of them. I'll just talk about one and talk about the impact of the other cases. But you all recall a case called Shelby County versus Holder. That was in 2013. There have been two additional cases, one last Supreme Court term and the Supreme Court term before that. Husted versus A. Philip Randolph Institute, another 5-4 decision, and Common Cause versus Rechko, another 5-4 decision. These three 5-4 decisions effectively insulate the political process in such a way that judicial review is very limited and structural inequality runs rampant in voting rights. In Shelby County, the court concluded that the Voting Rights Act was really unnecessary. It was unconstitutional because it treated similarly situated states differently. It violated principles of federalism and equal sovereignty of the states. And it departed from the basic principles of federalism by imposing a remedial framework on states, which was currently unjustified by current needs. In other words, the discrimination of the 60s is over with, and we need to move forward. Chief Justice Roberts even says history did not end in 1965, and we keep amending the Voting Rights Act on evidence that is old. We need an indication of new discrimination, and the court concludes that there's no evidence of that. The Shelby County decision actually spawned a series of ostensibly neutral voting reforms by the states, such as voter identification laws, polling center time changes, voting roll purges, all in the name of eliminating voter fraud. This contrivance has actually negatively impacted the voting rights of people of color and resulted in voter suppression. So Husted is really the voter purging case. Over 1 million voters were purged from the polls simply for not returning a registration card when they may have voted in previous elections. Common Cause versus Rutschko says that political gerrymandering cases are non-justiciable. And certainly Democratic and Republican parties engage in this. Elections have consequences. But the court in all of these cases readily ignores the present day effects of structural inequality. The court affirms process values that perpetuate structural inequality by insulating all of these practices from judicial review. The court in Common Cause versus Rutschko says there's no way to evaluate what fairness is in the political process, and we'll stay our hand in terms of analyzing and reviewing the practices of political parties. I would argue that with both decisions, the court has left it to the states to define the protections that will be appropriate under the gutted Voting Rights Act. In effect, the court has gutted the Voting Rights Act and left it to the states to shape applicable remedies for voter suppression. To me, that's federalism run amok. This neutral approach under the guise of federalism will ultimately lead to dilution of votes and further suppression of the votes of historically disempowered groups, discrete and insular minorities. The Constitution will survive because it has to. It is 231 years old, and there is no other choice. The Constitution survived the pandemic of 1918, and it will survive this series of pandemics as well. But it is up to the people. We cannot simply rely on the structural Constitution and the faith that things will get better if we just wait. We must act. Vote and make sure that your vote counts. Organize and make sure your vote is heard. Do not accept facile arguments that distort reality and lack critical rigor, and believe that you can make the Constitution's protections work. That means that we should not rationalize oppression and subordination through neutral explanations. There's no longer room in public discourse for "that's just the way things are." We should be discussing what America can and should be. So push back on all neutral rationalizations that preserve inequality and lead to a pandemic racial explosion. Push back on the voter fraud myth and advocate for full access to the polls, extended voting hours, a national voting holiday, a postal service, and a voting apparatus that is fully functional, operational, and works. Reject the notion of the heritage of Confederate monuments because it cannot be disconnected from a legacy of oppression based on Black pain and subjugation. The monuments re-envision a noble history that never existed and never asked the question, whose heritage and why does this fraught interpretation get privileged? Think about a new political party, or at least structural reforms that would serve as a safety switch for our democracy. One thing that our current situation shows us, notwithstanding party affiliation, is that our democracy is ill-equipped to deal with the undermining of basic norms, most notably a free press. Do not trivialize the Black Lives Matter movement or universalize it with post-racial neutral rhetoric like all lives matter. Only if that were true. If all lives matter, a lot more Black and brown people would be alive today because they would have been valued, not dehumanized. They would have been respected as citizens, not presumptively criminalized. Do not conflate principled protests with violence, looting, and rioting. You don't have to excuse such conduct, but you must recognize why it is happening. Recognize that disproportionate impact, as illustrated by all of the pandemics, is real and a product of many systemic choices rooted in an intentional effort to normalize oppression in schools, political processes, post-secondary education, employment law, housing law, and voting rights, and the list goes on. The Constitution can survive the pandemic, but we must nurture it, protect it, and invigorate it so that it does. Thank you.
Thank you very much, Professor Markison. And now I think we're going to turn it over to Jeremy Wells to start the ball rolling with respect to questions. Jeremy?
I'll invite everyone, if you have a question for a specific panelist, when you use the chat room to send me that question, please indicate if it's for a specific panelist. If it's a question for the panel, indicate that. Our first question is a specific one. It's for Professor Powell, and it's a question about hope. Are you hopeful about the outcome of the third Reconstruction going on now?
Well, my answer is yes and no. We go up and down. Look, right after the Civil War, we had maybe 12 years. Right after Brown versus Board of Education, maybe 20 years, and we're in it now. So I think America goes up and down, but the majesty of America is striving for what we think America should be. So I'm hopeful in the struggle, but I realize progress is limited. But that is the nobility of struggle. Derek Bell once talked about the permanence of racism, but he said that there's nobility in struggle. So you recognize it for what it is and do what you can to move forward. So yes and no.
While others are sending me their questions, I might take that question about hope and the third Reconstruction and send it to our other panelists.
Professor Markison, you can go first.
Okay, sure. I mean, I loved Cedric's answer. The yes and no of that, I think, is so representative of our history and our present moment. that our history gives us reason for pessimism, where there has always been backlash against progress, forces who feel threatened by the gains of others, by progressive reforms, push back, and we end up with Jim Crow as a response to Reconstruction. And so it's hard to be truly optimistic that we will be able to come through this with a greater understanding, with some higher level of racial reconciliation, with some appreciation for the proper role of government as well. But when I see some signs that there is the possibility of dialogue across groups, that there is responsiveness, at least on the part of some of our institutions, to the demands of our time, then I see at least the possibility for some measure of progress. So I guess I echo what Professor Powell said, in that I guess it depends on how I'm feeling that day to some extent, which part of that yin and yang seems more in ascendance on a particular day.
I definitely will agree with 9/10 of what we've heard thus far. I think that my embrace of conflict is not a romantic view of conflict, but it's the hope that conflict itself is an expression of diverse, free, engaged citizens who exercise the right to vote and have the right to express themselves politically, not just at the national level, but at the local and state level. So the moment that we're in right now, I think that it's tempting to be nostalgic. And there are those of us on the left or the right here in this group that might be nostalgic. To what era would you rather be transported? What is the perfect time? I wouldn't think that anything before the Civil Rights Act or the Voting Rights Act would be acceptable to most people. Let's not romanticize the Vietnam War. Let's not romanticize the criminal syndicate of the Nixon administration and the lying of the bombing of Cambodia and Laos. Is that the ideal time? Or what about the growth of economic and income inequality, the demonization of poor people in the 1980s, the extension and then the deregulation of some of these very important stoppers that have only exacerbated economic and income inequality through the 1990s? I don't think that we should romanticize the early 2000s. If you Google the cost of war project at Brown University, you will not only see chilling numbers of dead, wounded, refugees, and the cost of war for the United States directly and indirectly estimated over $6 trillion, including care for our wounded veterans. There is no question that we are hampered today in many of our fights against the pandemic, against social inequality and economic inequality because of the budget deficits and debt that came from a lack of conflict. So what I'd like to argue is that we have to be careful. If partisan strife is replaced by partisan strife, meaning that the only thing we can hope for is that our side wins all, and our side avoids deliberation, our side avoids hard questions, then we're really not making much progress at all. The separation of power system, as flawed as it may be, with the ideas of the limited number of participants that the founders envisioned, is nevertheless not the best, but one way to force an otherwise partisan system to reckon with the different perspectives on the same crucial and even existential issues that face us today.
Can I push back on that just a little bit? I agree with everything you just said, but I worry that some of the changes we've seen in the way our political system operates has made that hope for the way we can reconcile different political views instead of just having political strife, has made that problematic at best and maybe put it beyond our reach. I'm thinking of things like the way we silo our receipt of news, that we don't have the same basic assumptions about the world in which we live. And so we talk past each other if we even try to talk to each other at all. And that makes that process of compromise between different political factions that I think Madison had in mind deeply hard. It's awfully hard to see how that is going to work in the world we have now of social media, of people listening to their own sources, whether they be purposefully falsified or not. That is part of why I believe that we're going to have to come out of this at the other end of the day with something transformed, that the structures we've had so far are not adequate to the task of achieving the goal that you just described and that I agree with, of having a system that channels political difference into accomplishments, progress, compromise. That's where I see the challenge.
Thank you. So it occurs to me that we may have gotten ahead of ourselves in inviting everyone to use the chat room to pose questions. As college professors, we have become all too accustomed to Zoom and its ins and outs. But if you haven't used Zoom as often, you may not know how to use chat. So I'm going to attempt a technical explanation here. If you take your mouse and hover it at the bottom of the screen, you'll see a row of buttons emerge. And right in the middle is a chat button. And when you click on that, it'll bring up, at least on my screen, it brings up a white column on the right side. And there you can see such things as me posting an invitation to everyone to send me a question. And I'll invite everyone to do so. As our panelists have already made evident, they have an extraordinary knowledge, not just of the law and of the Constitution, but also of history. So if you had a Marbury versus Madison question that you've always been dying to ask someone, now's your chance. They seem ready to handle anything. Here's our next question. So our underlying issues have to be addressed in a political context, but by emphasizing the political side, do you worry that you may damage the credibility of Supreme Court decisions? Isn't that dangerous? If Bush v. Gore were decided today, would it be accepted? That may be a lot of questions as I'm reading it. That's a question or a series of questions for the panel: politics, the Supreme Court, Bush v. Gore.
Well, I'll just start by reiterating that I'm a skeptic of the idea that the Supreme Court is the last word on anything. And with all due respect to my legal colleagues here, the Constitution is a democratic constitution, not the party, but the principle. Every time Congress votes, whether it cites the clause in the article, it is interpreting the Constitution. Every time the president issues an executive order, any president is interpreting the Constitution. Yes, of course, the courts are in the mix, but they're a very passive institution. Courts do not welcome all conflicts, and conflicts must bubble up through very important standing, injury, ripeness, mootness, and other doctrinal hurdles. And therefore, the court does not have a constitutional hand in some of the most important issues of the day. For example, war. There are many separation of powers conflicts that federal courts are really allergic to. They might beat their chest and say, well, we're good at a lot of things, but they're not good at separation of powers. They don't welcome separation of powers cases, and they certainly don't welcome war powers cases. They much prefer the political branches to do the battles for themselves. Sometimes the court throws things back to the states and says that it's all right for the states to advocate for themselves through the election process of the House and Senate, where those members of Congress are not beamed from outer space. They are actually from the states. The states do get representation in the federal government through structural, regular processes. So I'm just a little hesitant to think that a 5-4 court decision, if it goes against the way you want it to be, is as legitimate as a full-fledged constitutional democracy, again, of well-informed and engaged conflict.
I agree with that to a certain extent. But the reason people focus on the Supreme Court is Marbury versus Madison. It's emphatically the province and duty of the judicial department to say what the law is. So that is the only branch that really does that. I think functionally what you're saying is correct. The Congress enacts laws, so they're legislating, interpreting the Constitution. The president, no matter the political party, if he is performing his duties or her duties, even as to make sure that the laws are faithfully executed, that is an interpretation. But here we see a skewing of norms. We have one branch interpreting the Constitution and imposing its will on the other two, most notably the executive and the judicial, and just sort of flaunting that. And so the system, and I think Sam pointed out, Professor Marcuson pointed out that there's a disruption in the system that these democratic norms are not really dealing with. And I even see a question from a good friend, Mary Ann Stenger. She says, to what extent is separation of powers undermined by one senator refusing to bring the vote anything but what the executive wants? So they're interpreting the Constitution, and I think that the court is a part of that. But these 5-4 decisions, they mean something, particularly when we talk about race, particularly when we talk about voting. I agree with your point about the expertise, institutional expertise, and the court may be falling short in terms of having the ability to deal with political and international questions. But I think some of the reason that we're having this discussion and where the questions are coming from is this fallacy that the US Supreme Court is above politics or apart from it. I think the institution is a political actor, and it imposes its will in various ways. And so I don't even think there's a way to resolve the discussion that we're having, because we're looking at the capacity of these institutions to impose their will. And sometimes that is enlarged. I think in today's current world, the executive is totally enlarged, with the Supreme Court sort of going along and rubber stamping things. Most recently in Voting Rights Act, not the 2013 case, but building upon that. And I think the court has always done that. It has reflected what the popular will has been. Sometimes that popular will has been to oppress, like Plessy, or to move away from substantive equality, like Brown, and then all of these other decisions that whittle away with it and end up in parents involved. So I think the court and the executive are expanding their power and imposing their will. And I don't think it's really a clean question to say, well, one institution does this apart from the other. I think they complement each other, and power rises and falls based upon the context that we're in.
Yeah, I would add to that that it's sort of a both and situation. I think you can absolutely agree that the court is not the only interpreter of the Constitution, and neither, by the way, are the executive and legislative branches. There's a public interpretation, and the public ascribes meaning to the Constitution that enters into that dialogue. And so too did the states through their actions, whether that be bringing lawsuits, whether that be passing legislation, while at the same time, while acknowledging that the role of the court is not as the sole interpreter, the sole interlocutor of the Constitution, we can also say that to the extent that the court has a role, there's the risk that that role can be diminished if the court is seen as illegitimate by any people who refuse to accept its decisions, if the court is inconsistent and contradictory in its decisions, if the court seems to be a political animal rather than trying to interpret the law. Those are all risks that the court can be diminished within its sphere, without saying that that sphere is the exclusive sphere of constitutional interpretation. So we can still, I think, worry about the court as an institution without necessarily feeling that that institutional role is one that gives it exclusive, the exclusive say-so over what the Constitution means.
I would just add that one of the reasons why Chief Justice John Roberts is more often than not these days a loose cannon, and he is straying from his conservative roots, is precisely the points that Professors Markuson and Powell are talking about. The court is weakened when it's politicized. The court is weakened when it's partisan. And the role of the chief is to look out for the institution. And anytime there's a 5-4 decision where you could just close your eyes and not even know what the question is, but you know what the lineup is, the court is losing its legitimacy. The court's legitimacy does not come from voters directly. When Anthony Kennedy stepped down, we have to remember, I tell this to my students, I always ask them, how many of you were alive in 1988 when he was appointed? How many of my students or your students were alive in the early 1990s and politically cognizant when Ruth Bader Ginsburg was appointed? So the court is very aware of all of the things that we're saying, and that's what makes it such a fascinating institution to study. They take cases carefully, as our legal colleagues could certainly attest. They are going to use their opinions very carefully to discuss the issues of the day. And they are also going to look out for themselves because, as Federalist 78 says, the court has neither purse nor sword, but merely judgment, and it must rely on the other institutions, I'm paraphrasing, for the implementation of its judgments. In other words, the court has no power to implement its own decisions. It has to be done by consensus, and that consensus is fragile. And if the court pushes too far, the consensus will be that the court has become yet another political branch and its decisions will be ignored.
When last I spoke, I had one question in reserve. I now have about a dozen. So that's great. Professor Powell mentioned a question from Marianne Stenger just a moment ago. Let me go back to that one and restate it. To what extent is separation of powers undermined by one senator refusing to bring to a vote anything but what the executive wants? That's a question for the panel.
Well, do you want a traditionalist answer or a democratic answer? The traditionalist answer is it's not undermined at all because it's embedded, the filibuster is embedded in the structure of the Senate, certainly by tradition, if not actually mentioned in the Constitution. And the idea that the majority leader at least has the power to control what happens on the floor and to demand that 60 votes, and it used to be even more before filibuster reform, that the Senate majority leader has that power. Now, historically, it has not been exercised in quite the extreme way that Senator McConnell has exercised it during his time as majority leader. There's been more give and take. And I think that's a reflection of polarization, that when you had a moderate middle in both parties who could work together as across party lines, it was much tougher for the majority leader to lord it over the Senate the way he has. And I guess I'll just put in a plug for an article I wrote last year in which I suggested a reform of the filibuster, and that would make the Senate more democratic, more amenable to open things being brought to the floor, and no one senator, neither Mitch McConnell nor anyone else, would be able to keep it off the floor as they currently can do forever. Basically, the filibuster can be maintained as long as 41 senators want to maintain it. My idea was to say, if the House passes a piece of legislation twice over 2 different sessions, then the Senate must take it up. That they've delayed, they've had the chance to convince the country that the bill is a bad idea, but delay is not the same as obstruction. And I think that would make the Senate an institution that, again, is more reflective than the House, which the founders clearly wanted, but would modernize it in a way that it will allow the Congress to be more functional and less dysfunctional.
Well, I'll chime in agreement. I think that some people might be familiar with John Rawls' book, A Theory of Justice, and he poses a very interesting question to the reader, which is, underneath or behind the veil of ignorance, how would you construct a fair society? The filibuster is that type of question because if you're in the minority party in the Senate, you love the filibuster. If you're in the majority, you hate it. Are we willing here to say objectively without knowing if we're winners or losers, how to structure American deliberation. I'm just throwing that out there. I'm not giving an answer. But I think that I agree certainly with Professor Markuson that there is the concept of norms. And I think that Marianne Stenger's question is along those lines too. We talk about presidential norms quite a bit and how President Trump is altering, even shattering certain presidential norms. Well, there are congressional norms too that have been altered almost beyond recognition. The Senate used to be a great deliberative body. Is it now? The House used to conduct very interesting, important historical oversight hearings. We used to have more robust committee systems across both chambers. We have become something different than perhaps we think we are across all the branches. When norms affect everyday politics through one lens and one dispositive fact, and that is which party is in control. If Democrats behave the same way that Republicans behave, I don't know if there's any net advantage for the system, regardless of how the outcome of the election is this year. Are you rooting for a despotic president of your own personal beliefs? What presidents say, and I'm not certainly equating any two presidents, but both Democratic and Republican presidents say, I was elected on these promises. Here I am now. I'm going to get around Congress through executive orders, other unilateral actions, and by deciding to sign and veto at the same time through a signing statement, meaning a president might sign a bill into law, but then say out loud that it's not going to adhere to certain provisions. In other words, I want us all to be careful and think through, what are you advocating for? And are you willing to be on the losing side of your own ideas if your party is in the minority? This is, again, a more rhetorical question. I'll cede to Professor Powell.
Well, I don't see the politics of it. I see it more as structural, actually. And I wouldn't say that it's winners or losers, is how the political process functions. So I think it was absolutely outrageous not to have a hearing on Merrick Garland. And so that, to me, Democrat or Republican, is a structural problem that we should try and identify. And we're not arguing for an expansion of power, but if advice and consent means something, pick and choose judges, vet them outside of the ABA, and then move them on to the court, which is a problem. That's a structural problem. And I'm probably certainly biased because the judges that I would like to see have not been appointed, and it will seem for a generation almost, because they're so young, and this is continuing to happen. So this is what we mean when we say elections have consequences. Now, I don't mean election has consequences so that I get into power and so I restructure all of the congressional districts and then I just put on all the judges. But there should be a give and take that is not present there. I think this particular president is hopefully an anomaly, and not talking about party or anything, but has so totally destroyed this notion of first principles. But it's not even him, it's the people who participate in it and provide a context for this to happen. And then we look at people as noble statesmen for saying what they should have said anyway because they're elected, but always really standing up to the president. Not really. I mean, we're 4 years into this, and now people are gaining courage. And those are people usually aren't people who are running again or people who aren't afraid for some reason. So I think the argument that you may be arguing for despotism on your side based upon political beliefs may prove too much. I'm making a more limited argument that there's something structural going on apart from politics that we should look at if one party, whatever the party that may be, is controlling everything, the legislative agenda, and particularly judicial appointments.
We have about a half an hour left and still a number of questions. I'm going to get to as many as I can and ask them in the order that they were sent to me. The next question comes from Jasmine Jones, and it's a big one. With our pandemics overlapping, both racial injustice and COVID, do we see a need for more of a federal response in the name of what's necessary and proper? or is too much federal meddling stomping on state sovereignty?
Well, no.
Frederick, go ahead.
Well, there's this notion of cooperative federalism. And I think the states have been taking the lead, quite honestly. So I think you could almost rephrase this question and say, should the federal government complement state action, state efforts, since there's been little to no guidance from the chief executive, other than go out on the market and compete against each other for equipment and supplies, do it yourself, and so those type of things. So I think this is another example of what we were just talking about. It's really difficult to talk about what federalism is now. I think federalism has been totally changed in terms of what does that mean. When you have states supplying the leadership, when it should be a complementary relationship, big F federalism, the Congress and the states still have their residuary power under the 10th Amendment and doing what they're supposed to do. But there is no complementary relationship. It's us against them, or we're autonomous and you're not, or I tell you what to do and you better do it, when it should be a cooperative effort. So a long-winded way of saying the states are taking the lead and the federal government needs to find a way to complement that. One way to do so would be having a national uniform policy across the board that sort of looks at opening, reopening, having a list of how things should function economically and in terms of healthcare. So the federal government has to send that signal, but it's the states that are on the ground.
Yeah, I think the federal role here, should the federal government, Congress most prominently, choose to use its power, is to borrow a phrase from the Constitution, the supreme law of the land. I think if Congress uses two of its powers to set policy, perhaps coordinating with the president in a perfect world, Congress can use its Commerce Clause powers, because clearly the effects of a global pandemic we have seen have enormous economic consequences on employment, on business failures, on foreclosures, et cetera, et cetera, et cetera. So the obvious impact on the interstate commerce of the country, the interstate economy of the country, would give Congress the foothold it would need to be able to pass regulations about how to deal with the pandemic if it chose that route. The other route it could choose is using its spending power. Congress could say to the states, here's all the money you need, or at least a good chunk of the money they need to deal with their budget problems, to deal with the shortfalls that are needed to buy equipment, to buy testing kits, et cetera. And Congress could say, but we're going to put strings on that. And the strings are, you have to have mandatory mask policies, because we're not going to just throw good money after bad and send money to states that are just going to perpetuate the continuation of the pandemic. And you're going to have policies that are uniform, as Cedric suggests, that when it comes to what kinds of public gatherings are permissible. You don't have to do that, Montana. You don't have to do that, Idaho, if you don't want to, but you're not going to get federal money if you don't. And that is a kind of cooperative federalism, although some folks think it's a little bit coercive. I think it would clearly be within the Supreme Court's jurisprudence about permissible uses of Congress's spending power. So the tools are there within our tradition, within our constitutional framework, for Congress, hopefully in coordination with the president, to take the lead and craft a uniform national response. And as Cedric suggests, the states would be on the ground implementing it in coordination with the CDC, HHS, et cetera. That's the way I would envision it. And I would not see that in any way as an infringement on the states or as overstepping by the federal government.
Well, I agree with both of these sets of comments, and I'll just add that the study of federalism is something that I think we need to do more of as a society. So I know that there are a few students, maybe they've just graduated. I see some of my old favorites here, including Jasmine, who posed this question. There are about 26 countries in the world that practice federalism to some degree. It would be an interesting question to see how they are behaving during the pandemic. So yes, the United States and Brazil are not doing well. But how is Mexico, Australia, or Canada, or Germany doing? So I'm not sure that federalism and some kind of local provincial rights are necessarily fragmented. It could be that there's a coordinated response if the political majority wants it. What I think that this proves to us is something that we may have needed to wake up to much, much longer ago, which is your life different because of what state you live in? In our lifetimes, we've thought about marriage, marijuana use, gambling, voting rights, taxation, school investment. These are all done at the state level to this day. Is it easier or harder to vote in Kentucky versus Wisconsin? These are things that the states do control. The states control a lot about our lives. I'm not saying it's good or bad, I'm just saying it is. And we are sometimes duped into thinking by either political party that this is a national government, and the first person we should think of when we wake up in the morning is the president, and the last person we should think of at night is the president. We are, as a state, looking at the governor. We're looking at the public health commissioner. We know the names of the members of the governor's cabinet for the first time. I'm not sure that routinely citizens of Louisville know every member of the city council as well as they might when we have certain local crises. Federalism is very important and it's often underplayed in American politics. The pandemic is showing an extreme version of it, but our racial reckoning has always been a federalism problem.
Our next question is from Steve Miller, and he's going to give you magic powers. It's for all of the panelists. So if you had a magic wand and could unilaterally he's going to let you create 2 or 3 amendments to the Constitution. We've only got 20 minutes. I'm going to limit you to 1. If you could enact 1 amendment to the Constitution that would be more effective in protecting the rights of people and preserving democracy, what would it be? You get to amend the Constitution. Doesn't have to be ratified by 3/4 of the states. What would you do?
Well, I've already told you one of mine, so I won't repeat that. Changing the Senate. That same article had a second proposal, and I'll mention that one now, and that is that there would be mandatory nonpartisan depoliticized districting by the states, that they would have to use neutral panels to do their districting so that you would solve the problem of gerrymandering, at least to a great degree. Gerrymandering would become much more rare. I think one of the most important effects that would create in the House of Representatives is that it would reinvigorate a middle. Our parties today have become, in the House in particular, although also now in the Senate, have become almost completely polarized. That is, the most conservative Democrat is still to the left of the most liberal Republican, almost perfectly. There's almost perfect polarization. And if you didn't have such gerrymandered districts in the House, more districts would become competitive. At least there'd be a handful of districts across the country, maybe 40 or 50 out of 435 would become competitive, such that whoever won that district would have to run to the middle. And if you created a caucus that would be some Democrats and some Republicans of 40 or 50 members who could be the basis for compromises to reach the kind of consensus that is necessary to jolt Congress out of its dysfunction, I think it would make a huge difference to the way our at least at the federal level, to how our democracy functions. So that's my magic wand proposal.
Can I have 4 magic wands? I'll be brief. So the Senate norms are interesting, but what about the fact that every state has 2 senators, and that really undermines the power of cities in the United States? So in a decade or two, about 70% of the United States population will live in 30% of the Senate seats. So let that sink in for a little bit. Is our disproportionate power for rural voters fair if 1 person, 1 vote exists? Another question is about the Electoral College, but I don't think I would abolish it. I would encourage more states to adopt the Maine and Nebraska view, which is that it's not winner take all, and that the Electoral College vote, which is completely up to states, by the way, Kentucky can split its 8 electoral votes to do it by congressional district, and then do 2 overall for the majority of the state. It's more fair. It allows for everybody to feel like their vote counts. I would also say that Congress should declare war, and it should have a beginning, a middle, and an end. We have 2 authorizations for the use of military force that were passed 2 presidents ago that were targeting 2 countries and have been used in up to 14 countries in an unending permanent green screen of war that has become invisible. And we don't even think about the fact that we're still at war when we have all these other issues at home, but we are at war. And what are the consequences and the costs of those wars, both for our national security and for blood and treasure? Last but not least, I'll tweak the crowd a little bit by reviving an old view that maybe the Supreme Court should have rotating, staggered 18-year terms and not life. Those are my thoughts.
They're very interesting. So I have to come up with something creative. So maybe, and this is my creative one, this amendment would just continually expand whenever we saw inequality in society. So I would take the John Lewis Voting Rights Advancement Act of 2020, make that a constitutional amendment, but change it to the Structural Inequality Amendment. So disproportionate impact would mean something, and the government would be able to do a series of audits. I think the government has done this before in contracting for women and people of color. There was a study done in the late 80s, early 90s about contracting, and then the federal government took action by using disadvantaged business enterprises. I think you could do the same thing and have a constitutional amendment that pinpoints all areas of society. So school integration, if you see that we're going back to resegregation like we have now, that would be something that would be pinpointed in this amendment, and Congress would automatically have to undertake a national policy to deal with it. Same thing with voting rights, what's happening now. So it wouldn't be this notion of retrogression and retrenchment whenever you see something that is being undermined. And even if it can be explained by some neutral or seemingly procedural aspect of the problem, if we see that these glaring disparities exist in society, then this constitutional amendment, the Structural Inequality Amendment, will allow Congress to take immediate action. Fast track from the House and then some type of approval in the Senate. Certainly haven't worked out the mechanics of it, but just identifying areas of society where there is structural inequality. And I think that would be productive. The legislative history could be the 1619 project and everything else that we've done that we have evidence of. And then we would have an auditing agency, and we would just take each segment of American society, examine it, and try and unpack the structural inequality that exists. So way out there, but something that if I had a magic wand, that's what I would do, something outlandish.
Our next question is from Ted Henson. He's going to bring us back to reality. He asks this question as a public health professional. He often says that public health policies and interventions often create tensions between health and well-being on the one hand, and personal liberty on the other. Seatbelt laws are the prime example of this historically. But now mask mandates are the source of fierce debate. If Biden's elected, he's called for a national mask mandate. Do you see this as being constitutional, enforceable, viable?
Well, first, I think it would have to be done, at least I can't think of another way you could do it other than through the spending clause, that the federal government would require states to impose that mandate, because the states would have to enforce it and make it a condition of federal spending given to the states, A, to enforce it, and B, to deal with other problems that states are facing as a result of the pandemic. I think under those conditions, it would be constitutional. Congress could say, states, if you want this money, you have to have a mask mandate, and then we would go from there. As opposed, I will say, so that's the federal power part of it. In terms of whether it's somehow in violation of people's individual liberties, that's in part what I was referring to in my opening remarks when I talked about extreme libertarianism. I have found very frustrating the whole political give and take, or the development, evolution of the discussion on how we respond to restrictions. We first had people objecting to the closure of restaurants or church services because of the infringement on their liberties, or because of the effect that would have on people's ability to maintain their business or to keep their job. And okay, that may seem like a reasonable objection, that somehow the government was overstepping and causing all of these infringements on liberty. It seems to me masks are the compromise. Masks are to say, oh, okay, we'll try to reopen, but we want to do it safely, so accept this lesser infringement. But I think by any reckoning, masks as a requirement to go to a church service or to go to a restaurant or to go to a sporting event is a lesser restriction than shutting down any of those activities completely. And yet the same people, at least for the most part, who objected to the closing of restaurants now object to wearing a mask. And I'm just going to say it bluntly, I'm over it. I don't think there is any individual liberty, legitimate individual liberty notion that says that you have a right to wear a mask or right to not wear a mask when there is scientific evidence that shows that that puts other people in danger, because you may be carrying around a disease that is potentially deadly and you don't even know you have it. Your right to not wear a mask ends where my right to life begins. So this is an easy one for me. If I was the federal judge and a claim was brought before me, it would be dismissed with the back of my hand.
I think there's going to be a lot of litigation, though, if Biden wins and he has this uniform mask policy, because I can see states saying, yes, you've offered us this option of accepting this money, but you're really coercing us into taking it. There's no other way that we could exercise it. And so what you're really doing is commandeering the state and imposing your will on us. And I agree with everything that Professor Marcuson said. I think that this notion of libertarianism has just run, it's been exaggerated, because now the individual is more important than the community if that individual can point to some type of enumerated right or self-crafted right that insulates that person from the community. And that's probably the worst thing that could happen in a time like this. But I understand that there was this similar protest in 1918. I wasn't aware of that. I just assumed that everyone went along and combated the first pandemic that we encountered in 1918. But this seems to be a strain that runs through American culture, this notion of exceptionalism, the rugged individual, I can remake myself, but that is coming at the expense of the community. So I think he could do it constitutionally. I just think that there'd be a number of court battles, and that's what's been happening with other initiatives. So this sort of underscores my point about the courts. The courts, in this particular instance, in this context, have been going along on some level with the program of Trump. They've been pushing back sometimes, but courts play a role in terms of articulating these democratic norms. And that's what's missing now in our society.
Well, I would just add very briefly that there are no real absolute rights, written or unwritten, that cannot be protected against a compelling interest of the government. So, for example, the First Amendment says Congress shall make no law. It couldn't be clearer than that, really. Congress shall make no law. And what is Congress not supposed to make a law on? Freedom of speech, freedom of the press, freedom of religion. But we regulate all of those things. You can't say certain things in an airport. You know that. You can't have any type of religious practice, anything at all. And you certainly can't, if you're a newspaper, publish troop movements under free press. So we've always regulated the so-called absolute freedoms that are actually written into the Constitution. So the next question would be, is being protected from a mask mandate a constitutional right? It seems very unlikely that a court would say that that is a legitimate, consistent view of the general welfare against an individual. Is it implementable though? That's the hard part. Can it be enforced? That's the hard part. American, as Professor Powell said, yes, we have a view of ourselves that is sometimes very bizarre and harming in a way, the way we want to express ourselves. However, we do have to accept that there may be legitimate arguments on both sides on some parts of the pandemic government response. And we also, going to the earlier question, might have to accept that some of these issues will devolve back to state government, and that Congress is made up of people from the House and Senate who are representing local and state interests. Again, there is no such, it's a national body made up of locally elected and state-based elected people. And Biden's election just brings us back to the beginning. Well, I wouldn't say it's Biden's election. I would say it's the House and Senate's election. And before we get ahead of ourselves, let's try to remember that Congress has legislative authority.
Great. Our next question, actually a couple of questions, related questions sent to me by Yuva May, and they're about how jury trials are happening right now. So are you aware of the way the court system is handling jury trials during the COVID pandemic, excluding from service, from jury service, potential jurors in high-risk categories and those without access to technology? Does this run afoul to a defendant's right to a fair cross-section of the community? That's number one. And related, additionally, courts are closed to public viewing attendance, but are available to listen in by phone or live stream. Is that consistent with the right to a public trial?
Well, I think on the second question, I think the answer is yes. I think the right to an open and public trial does not have to have any particular form, although it traditionally has been you can just walk into the courtroom, but it doesn't have to be in an era where we have the technology to allow broadcasts of court proceedings. And even if we might quarrel with whether that in normal times would be an adequate open and public trial, I believe the courts would hold that under these circumstances, as Professor Ferrier just said, no rights are absolute, that is a means to the end, if an imperfect one, of keeping trials open, but making sure we balance that against, for example, the right to a speedy trial. Because if we're going to delay until the end of the pandemic, a whole lot of criminal cases are going to sit on dockets for months on end. And that is at least as big a problem. I don't want to say it's a bigger problem, but at least as big a problem as the issues of open and public trials or the right to a jury trial with a jury that is a fair cross-section of the community. So I think when we're trying to balance all of those considerations, doing it the way courts are trying to do it, I think they will have a lot of play in the joints in order as they craft solutions that try to deal with these problems.
I'm passing on this one to defer to my expert colleagues.
Yeah, that's beyond my area of expertise too, but I agree with what Sam said. I think to the fair cross-section of the community, I think that's going to be impacted by the context that we're in. And there's never been a totally fair cross-section of the community proportionately. You could always make arguments, but I think the system is limited now, and you sort of have to use the pool that you have. And so that becomes a fair cross-section of the community. It's never going to be perfect. I don't think it's an absolute standard.
We are at 8:27 p.m., which does not give me enough time, unfortunately, to ask any additional questions. My apologies to those that we didn't get to. Lots of interesting questions. I will invite our president, Paul, to end our proceedings.
Well, thank you, Jeremy, for factoring through all those great questions. All I can say is that was a fast 90 minutes. I want to thank our panelists, our moderator, and all of you for joining us this evening for what's been an interesting, insightful, and enjoyable discussion of the impact of our very unique and challenging times of 2020 on the United States Constitution. On behalf of the Phi Beta Kappa Association of Kentuckiana, I would like to virtually present a small token of our appreciation to each of our panelists and our moderator this evening. I don't know if you can really make this out, but it is a Jefferson Cup with the Phi Beta Kappa insignia. One that you can actually display and use will be coming your way in the mail. And I hope many of you can join us for our author forum featuring Cassie Chambers Armstrong 1 month from tonight, October 15th. And with that, we'll conclude our program for this evening. Again, thanks to everyone for being a part of it, and good evening.
Good evening. Thank you so much.
Thank you.
Thank you very much. That was very enlightening. I've learned a lot. I have plenty to think about as we move forward. What a very sharp audience too. Such engaging questions.
I enjoyed it, Jasmine. We haven't worked together in years.
I know. And we're still only one building away, the three of us. We should have coffee sometime.
Exactly.
Here, here.
Yeah.
Thank you all. Thank you, Paul, again. Thank you, Jeremy. Thank you, Greg. And thank you, Gail. It was delightful.
Thank you.
Thanks
to all of you.
We had a good time.
Good night.
Thank you.
Good night.
Good night.